Doug, you need to get Ms. Hayes, or at least stand in the hallway.
Yeah, I want you to do that.
That's bad, but.
Of course. Hello, Mr. Brown.
Aren't you glad you're sitting up here now?
I'm earning my money then, right? Probably Ms. Hayes should be here. She, since she already been issued. She's left. Okay. Okay. Sit tight for that. Okay, on the record? We are indeed. Okay, Mr. Watson, I'd ask you to come to the podium, please, sir. Okay, so I told you earlier that I reviewed the tape, and I considered arguments of counsel, and here's where I come down on this. So the facts aren't really in dispute. Mr. Watson, to his credit, I think, admitted, and with quite good candor to the court, exactly what happened, was consistent with the witness, and so the question became, what's the proper remedy here, since, again, the facts are not really in dispute. And this is what I find, based on what I observed in my review of the tape and Mr. Watson's statements to me. I find that he did intentionally dismiss the witness with the understanding, even though he may not have been in court right then when Ms. Watson said it, that Ms. Sharp was going to call him as her witness. And I conclude that that was highly improper, based on the statutes and the criminal rules of procedure that were cited earlier, that state that only the court can release a witness. So it was particularly improper in this case, given that it was, as you stated, strategically done to prevent the defendant from eliciting testimony, which may or may not have been favorable to Ms. Bennett. And I don't know what would have happened if that witness would have been called. You might have objected. I might have allowed some of it in, some not. The problem is that you prevented the court from making that ruling. You prevented Ms. Sharp from having the opportunity to attempt to elicit that testimony. So again, I find that highly improper. I find that Mr. Watson's actions also deprived Ms. Bennett of a fair trial, based on what I said before, and furthermore based on the dynamics that went on in court when Ms. Sharp was at the podium calling the witness and the jury making the observations that they did. So therefore, I am granting a mistrial with prejudice at this time. I think Mr. Watson, frankly, is an outstanding advocate, and I appreciate his normal excellent contributions to the administration of justice in this courtroom. I think that, I'm thinking, I wrote this down, so let me just stick to my thoughts that I put on paper. I think his actions yesterday clearly crossed the line. And I think that he would be wise to remember and review the rules of professional conduct and the special obligations of a prosecutor, that you're a minister of justice and not just an advocate, as outlined in the Florida Bar Rules Regulating Professional Regulation, and they've adopted some of the ABA standards as well. So there may be some further communication with you, sir, and with your office regarding those rules and the application of them. Certainly, I expect them to be followed in this courtroom, and not to have that sort of behavior, which I view, again, as highly improper again. So the motion for mistrial with prejudice is granted, and that's the court's ruling. Thanks, sir. At this time, I'm going to have the jury come up, and I'm going to dismiss them at this time.